Now we're going to discuss legal philosophy. Alright, philosophy of law. Philosophy of law will ask two questions. A conceptual question of what law is, and a normative question of what law should be. It is a central tenet of most of philosophy of law that these two questions are separate and can be studied separately. The existence of law then is one thing, its moral merit or demerit, whether it should be like this or should be in a different way, that's something else. These are two different forms of inquiry. Later we will see that some authors, more exceptionally, think that there are situations in which these two questions cannot be separated. Let's first then begin with the question of what law is, assuming that it can be separated from the question of what law should be. The book touches upon the work of Hart and the work of Dworkin. Before talking about Hart and Dworkin, I want to talk about Austin, because Austin is a figure against which Hart wrote, and then Dworkin wrote against Hart in turn. So I think we get a better picture of the development of legal philosophy if we begin with Austin. Here is something that you find if you Google Austin's theory of law, the first hit. Austin argues that laws are rules which define as a type of command. Laws are general commands issued by a sovereign to the members of an independent political society and are backed up by credible threats of punishment or other consequences, that is, sanctions, in the event of non-compliance. So essentially, the Austinian theory of law is that law is a command backed up by sanction. I think there's a lot of good to be said about this theory. And then we can contrast it with the theory of Hart and the theory of Dworkin. And I think that if we do that with a very clear mind, we might come up with the idea that Austin's theory is superior. In Austin's theory of law, we can see that law depends on power. There can be no law without power because then you do not have the power to punish, the power to issue those sanctions in case of non-compliance. The Austinian theory of law makes law as something that can be empirically investigated. I can investigate for every society which are the rules that have been issued by an authority and whether that authority has or does not have the power to punish. The Austinian theory of law makes the importance of law tangible. Law is a matter of fact and it has consequences attached to it. Law is not a matter of opinion or psychology. But then the legal philosopher that has really set the tone for discussing what is law in the 20th century and still up to today was H.L.A. Hart. H.L.A. Hart started his work, The Concept of Law, with an attack on Austin. He found he found three objections that he found very significant against Austin, which are that for Austin, mere force would be enough to have law, so you would become a sovereign. Austin did not define a sovereign in any moral or sociological sense. A sovereign for Austin is simply the authority that has the power to get obeyed. And then Hart said, well, if you do it like that, you cannot differentiate law from the rule of bandits. Hart also thought that Austin had difficulty with what he called power conferring rules. So power conferring rules are rules that are not, it's not the typical rule. If you park here, you will get punished, or doing this is illegal. But a power conferring rule is rather a rule by virtue of which said that I have the power to enter into contracts, or the certain administrative law authority has the power to issue regulations. Said, well, those rules are not about conduct. Those rules are about statuses, and Austin cannot really explain them. And finally, Hart thought that Austin could not explain international law, which we have the intuition is law. As we know, international law, there's really no sanctioning body, and nonetheless we're tempted to call it law. Then how can we explain that international law is law? I think these three questions are actually very unprofitable questions. I will see later, Austin has a very good reply to all of them. But then Hart came up with an idea of law being based on a rule of recognition. Said, well, law is not then simply a command with a threat of sanction, because that cannot explain how a band of robbers does not really make law. Law is based on social acceptance. So law is what a society accepts to be law. So this is based on a certain, he called this the rule of recognition. So we'd say, for example, for the Dutch society, there will be an acceptance, socially speaking, this social sociological fact, that for the Dutch, they believe in the rule that whatever parliament passes as law is law. So that would be a sort of rule of recognition. The social rule, a social belief, something like the customary law of opinio juris and behavior, that Dutch society believes that a rule passed by parliament is law. So then notice that acceptance here is not the same as consent. Think about it like this. For a lot of Americans, it's really very bad that Donald Trump is the president. They do not consent for Donald Trump to be the president. If it were up to them, it would have been somebody else. But still, they accept it. They accept it as a social fact that Donald Trump is the president. Law then is a little bit like fashion, etiquette, or money. These social phenomena, fashion, etiquette, and money, the reason something is fashionable is because society accepts it to be. That does not mean that we agree to it. We can see, oh, this fashion is terrible, but we know that this thing is fashionable or it's not. And we cannot find any other better answer about why something is fashionable or why something is considered to be ethically correct, like etiquettally correct as a matter of etiquette, than the fact that a certain society has agreed that it is. So by the rule of recognition, law is still empirical, but only halfway. Because with Austin, I can see law being a matter of empirical decision at the level of qualitative and quantitative research, whereas in the case of Hart, it seems to be more about empirical research, but more at the level of psychology or anthropology, more at a purely qualitative level. So we would want to know, as an anthropological fact, what sort of rules a certain society accepts as being legal in nature. And then, just as Hart criticized Austin, one of the students of Hart, Ronald Dworkin, ended up working against Hart, ended up criticizing Hart, and developed this third big theory that we're going to study today, the theory of Dworkin. So essentially, Dworkin's criticism to Hart is to say that he had a donut theory of law. So donut is a circle of dough and a hole in the middle. And he said, if you think that law is a social creation and only a social creation, if laws like fashion, like etiquette, well, naturally then law will have holes. Because law depends on what society has made, society will not have thought about every scenario, and then naturally there will be gaps in the law. And for Dworkin, this is intolerable. He said this is not how things should be correct, this is not how judges see things. We always ask ourselves, in a difficult scenario, what is the right answer? We do not believe that really law has holes. We do not think that law has gaps. We rather think that we must think very hard and think morally and think spiritually what is the right answer for those difficult questions in which apparently there will be a hole. But if we look at it really hard, if you interpret it correctly, you will find that law will always have an answer. So he did not accept the idea that law is a social creation. As a social creation, law will have gaps. He did not accept that. He says law is always the full and perfect cloth. It is actually law properly understood does not have gaps. And how are the gaps filled? Well, here's where Dworkin comes in with his idea of principles. So society creates rules. Those rules are based on the rule of recognition. Okay, no problem. The rule of recognition says that for the Dutch, they recognize whatever the Dutch parliament says as law. That's fine, but that's not the whole story, Dworkin would say. You also have alongside that, you also have principles. Principles are not law because they have been laid down. They are law because they're morally right. And it's rules plus principles which forms the body of the law. Law then is not really a donut. Law is more like a Berliner. And you have the dough around it, but in the whole you have jelly. You have this also delicious thing, which is no longer a rule, but rather a principle. It is something else. It does not come from the legislator. It does not come from the rule of recognition. Rather, it comes from pure moral reasoning. And then law has this dual nature, this hybrid nature, between the rules that exist because they're socially accepted and the rules that exist because they're right, or rather the principles. Now, I want to say that this has some interesting degree of plausibility. Consider the principle of equality. I do not think there's any legal system that can get off the ground without some form of notion of equality. It can be equality with exceptions. It can be, for example, that a certain group of people are excluded from equality and they're mistreated, or they're treated as nobles and they're treated as kings. But to some extent, you will have to have some dimension of equality to have a legal system. But however, I am still a little bit unhappy with saying that that has no other explanation besides a purely moral one. Because if you see what's happening here with Dworkin, all ambitions to empiricism are absolutely gone. Whereas in Austin, the definition of law would make law 100% amenable to empirical inquiry, and in Hart it's still empirical but more of a psychological and anthropological inquiry. In Dworkin, empirism goes out of the window. To understand what law is, you will have to do an empirical inquiry on the one hand, and on the other hand, a moral inquiry. And if you have the opinion that moral inquiry is probably not such of a nature that it can really be settled, then you will be worried about the scientific credentials of this approach. Now let's go back to Austin and ask ourselves whether the problems that have been identified by Hart and Dworkin are actually really problems for his theory of law, because I think Austin's theory of law has really a lot to be said for it, because of its simplicity and its amenability to empirical inquiry, and because of its basic realism. So for starters, there's the idea of Hart that Austin theory will not allow us to distinguish the rule of law between a rule of a band of robbers, a band of thieves. But then really, is this a problem? Maybe it's actually good and correct that we understand that rules are rules however they go, and that the distinguishing between the rule of the state and the rule of a band of robbers will depend on their justice, not on the sort of rule that they are using. Maybe it's actually an analytical benefit of Austin that it will desacralize the state and see the state as potentially not all that different from a band of thieves, except depending on its justice, of which he says nothing, of which we have to come up with our own analysis, our own assessment. So maybe that is actually positive and not negative. That in relation to power conferring rules, the reality is that in civil law jurisdictions, for really a long time, power conferring rules have also been understood as involving sanctions. If I operate outside the power conferring rules that have been granted to me, there's a sanction that's called nullity. If I try to make an administrative act and I do not have the competence for it, that administrative act will be void. And that voiding is typically understood in the civil law jurisdiction as a form of sanction. So this being very natural to me, having studied in the civil law, I have no difficulty thinking of nullities as form of sanctions and fitting within the Austinian paradigm. And finally, I think Dworkin is very correct in identifying that beyond rules, there are also principles. But I think whereas this is not really a problem for the Austinian theory, because there's no problem with the sovereign issuing rules and principles, or even tacitly accepting principles. Austin himself accepted the idea that law is sometimes commanded explicitly, but other times implicitly commanded. And we can all understand from normal life that there's such a thing as implicit commands. So I see absolutely no difficulty in finding that principles could also be issued by the authority of the sovereign. And finally, in relation to international law, I am rather happy to let the chips fall where they may, and say, well, if international law turns out not to be 100% law in the Austinian perspective, that's not something that should necessarily scare us. Political scientists have done really good work on international law by taking a step away from the idea of law and thinking more in terms of norms. And they have found enough of interest in international norms without entering into considerations of whether it's legally binding or not. So I think international law would actually flourish even further if we cease to try to understand it as law and rather we understand it as a system of social norms. So there's a lot to be said for going back to Austin, just as an opinion. Now we move on to the next topic, which is about what the law should be. Most people see the issue of what the law should be as different, as separate from the issue of what the law is. Even people in the so-called natural law tradition can still very easily make this distinction. For example, Aquinas would have no problem saying that a bad law, that a morally bad law, still exists. The exact nature of its existence, of course, Aquinas would have a lot of resources to say something complicated about that, and he may say, well, a bad law is like a fake diamond, which is not a diamond, or maybe it's like a rotten fruit, which is a fruit but a very bad fruit. I think he would have no problem working with his very complicated philosophy and finding a way to understand law that is morally bad, that it's morally very bad, as still in some important sense being existing law. It is later in the 20th century really where we see a strong trend of moralism, and then we see in the work of Radbruch already the idea that law, when it's sufficiently bad, when it's sufficiently vicious, it actually ceases to be law. And it's really working once more when we hit the ceiling of moralism, where he says that law actually is what morality says it should be. The two questions are not different. You must take them together, and to analyze what law is, you must understand law as what it's morally it's best for it to be. I think there is a lot of benefit in keeping the distinction between what law is and what it should be, so I would take the path of Austin or Aquinas here and try to keep those two terms as separate and analyze on the one hand the issue of reality and effectiveness and power, and analyze in a very different light the issue of it being good or bad. As for what the law should be, well, for Aquinas, the answer is that the law should lean towards the common good. To work with the idea of the common good in Aquinas is actually very difficult for us today because it's a form of thinking that's very lost to us, that it's very arcane, that's very archaic for us. When Aquinas says that human beings have a common good and that the law should direct us to that, he is not saying simply that human beings have a lot of wants and that the law should maximize one satisfaction. So rather he's saying that the idea is that there are forms of life that are objectively good for human beings, as such, generally speaking, broadly speaking, and that the law should try to take us there, that the law should do essentially the role of a tool to take us towards the common good. So in a way you could think about Aquinas as something like an objective utilitarian. So whether a utilitarian would say, well, what the law should do is maximize the preferences of everybody, Aquinas would agree with that, but it would switch the idea of preference for the idea of benefits or good. And then the idea would be that's not about your preference. A preference is subjective. I can have a preference for drugs, I can have a preference for alcohol, and those may not be good for me. He would say, well, you must direct the law to what would benefit human beings, to what's objectively beneficial for them, not necessarily for their preferences, because their preferences can be incorrect. So that would be essentially how I would read Aquinas today. A super quick aside. There is a feeling when you study somebody like Aquinas and the idea that law should be directed towards the common good, there's a feeling that this will be unacceptably moralistic in the pejorative sense, And we know what moralism in the pejorative sense mean. Now, we know when we see the work of people like Peter Singer, who are pinning on people an increasingly unlimited burden of obligations, and which see no problem with killing or murdering people if that's going to be for the common good. And we also, of course, naturally see it in more conservative works that will not allow you to read certain books or will not allow you to listen to certain songs and so forth because they consider to be against the common good. And I want to say that the idea here is probably best handled by going from Aquinas through Mill and saying with Mill that the human good, what is good for human beings, is alloyed with freedom. To understand what's good for us as the rational creatures that we are, we also have to understand our freedom. Our freedom has to be part of the story. Freedom has to be part of the bargain. And then it's not acceptable to have a system where people's freedom gets completely crushed, either because of moralistic rules that you shouldn't read certain books or listen to certain songs, or that you must be of so and so manner, but also not by the modern moralism of people like Peter Singer, who believe that we should be crushed by the burden of morality, of an infinite burden of moral blame. I would say, following Mill, that both of these options are wrong, and these options are wrong actually because in being moralistic they are immoral. In going against freedom they crush a very essential aspect of the human good. But that's just an aside that I felt very necessary to say, because in these times we're living, a lot of what I said can be misinterpreted. Or let's rather say the idea of the common good can be very easily misinterpreted. And then by contrast we have Hobbes. And the contrast between Hobbes and Aquinas is really a wonderful one, because there are actually two authors that are very close to each other in terms of, in a certain way, and in another way they're extremely distant. So in what way are they close to each other? Well, they both accept a teleological view of reason. And I cannot enter into the details of what teleological means here. So essentially what they say is to be rational is to act effectively. So they agree with that, and that's very different, for example, to Kant, for whom to be rational is not to be effective but to follow universal rules. So Kant has morality inbuilt into his theory of action. By contrast, Aquinas and Hobbes, they're both teleological thinkers. For them to act rational is to act effectively first and foremost, and then morality is built on top of that. Morality is derived from there. It's not there at the bottom. And that way they're very close to each other. But then they lived under very different times. Whereas Aquinas lived through a period of stability and rather good fortune in the late Middle Ages, Hobbes saw the wars of religion, and they saw the extent to which humans can brutalize other humans over differences. He saw that very quickly and very closely, and especially, let's say, within Christians. So then Hobbes came up with a much more pessimistic idea of what the law should be, a much more minimalistic idea of what the law should be. He said human beings do not have a common good, they just have interests. There's no this thing that's good for all of us. You have your good, I have my good, she has her good, they have their good. That is, they all have their own subjective interests. And from that, there's no possibility to get this overall view of a common good that's good for all of us. That doesn't exist. Or if it exists, it's simply just this order. That's all. Our common good is simply an order that secures the peace, where I can search for my private good and you can search for your own private good more effectively, more efficiently. So essentially, the law is this. The law is an order whose benefit to us is simply to give us a framework where we can seek our selfish aims without coming into war with the selfish aims of others. So then for Aquinas, the law should be directed towards something. The law should be to a common good. And here you can think that Aquinas would favor teleological interpretation of the law, more or less in the way you saw it, for example, in Obergefell versus Hodges. Hobbes, by contrast, would be much more of a literalist. Say, well, teleology aim the law towards good. Which good? Mine or yours? No, the law should be just respected as it is, because the benefit of the law is to be this order that gives us some predictability, stability, and peace where we can all seek our goods. If we try to teleologically interpret the law towards the good, quote unquote, what we're only going to do is to interpret the law for the benefit of certain groups or certain people against the benefit of others. And that should not be allowed. That should not be permitted. The law, to serve its role, to serve its function, it simply must exist literally and be enforced predictably to allow each of us to have peace in our, let's say, in our square meter of freedom, and then seek our aim in our square meter of freedom. Now, just like I defended Austin against Hart and Dworkin, I'm going to say something in defense of Aquinas against Hobbes. So just as I defended the idea that law should be realistic, that a theory of law should be realistic and empirical, because there's a lot to lose if we enter into the more moralistic analysis, especially in Dworkin, I'm going to say that the theory of what law should be should remain moral, and then it should be a little bit more ambitious than what Hobbes agreed to. And here I'm going to say essentially that Hobbes is unrealistic. Because what Hobbes tries to do is to have a moral theory without morality. He tries to have a moral theory simply based on purely neutral concepts like order, stability, and the idea that our own selfish preferences will be better served by a system of whatever these selfish preferences may be, will be better served by a system of order and stability than by anarchy. So the problem I have with Hobbes, and Hobbes' theory is wonderful, and it's very tempting, especially because we're living today an era of fragmentation, not in a way dissimilar to the wars of religion that Hobbes lived through, although for now we do not really have conflict, let's say violent conflict. But the problems with Hobbes' idea is ultimately that it's unrealistic. Hobbes assumes that purely selfish concern will be sufficient to justify a system of order. So he says, well, you have your own selfish concerns, and so does he. We all attending to our selfish concerns. We will have a system of order and stability because that will be better for us. But that is predicated on the idea that selfishly, that's the best you can do. But the problem is that it isn't. The problem is that it's very possible for selfish groups to dominate other individuals forever, or at least for centuries, or maybe even for millennia. And this is something that we have seen already with the crime of slavery. The problem of slavery is that it was stable, it was socially stable. And then that's why just trying to take morality out of the picture and saying, well, it's just a matter of order and stability is not enough, because you're going to have systems that are stable and orderly, but that are abject and inhuman. So in that way, I think Hobbes is unrealistic. So he misses out on. So he says, well, individuals, we're all fragile, and we have it's in our interest to join these rules, to abide by these rules, to have a peace. Well, individuals are fragile, but groups are not. And groups can join together and oppress other individuals or other groups for a very, very long time. And then the only answer to that is that it's unjust. The only answer to that is that it's actually morally wrong. So you cannot actually make morality disappear. And on top of that, Hobbes has a lot of difficulty. Let's say the Hobbesian way of thinking, which is based on simply bargaining between selfish individuals, is completely non-responsive to the situation of infants, children, or persons with severe disabilities. For these, I think Hobbes has very little answer. If we think selfishly, why should I respect infants when they are not capable of offering me anything in return? And that's where I think Hobbes has a lot of problems. And then the idea, maybe a little bit to end in a certain vision, is that it makes sense to have a realistic theory of law, and it makes sense to have a moralistic hopefully not in the pejorative sense of the word, but it makes sense to have a moralistic theory of what the law should be.